that we need her to sign this. It needs to be notarized, and there needs to be 2 witnesses. Okay? All right, thank you. Hello, my name is Bob Arnold. I'm a business attorney here in Miami. Actually, just general corporate work is probably my prime bread and butter, but I also do real estate transactions, arbitration, and bankruptcy. I basically take a business through its life cycle from the beginning, startup phase, through the middle where they're expanding or where they need some kind of additional capital or a partner or whatever, all the way to the unfortunate end, which tends to happen, and it has been happening, unfortunately, quite a bit more these days. So the first case study is a commercial lease. It's a very simple document that many people get into, but this is a story of a client who came to me after the fact. They had signed a commercial lease and they didn't have an attorney review it before they signed it, and because of that, it was something that basically turned out a lot worse than it should have. The document was prepared by the landlord. It was a standard form agreement prepared by the landlord. Obviously, he had been in the business for a long time, so he knew what the weaknesses were with the potential tenants, and he exploited them. He had some clauses in there that obviously, if there were any sort of legal actions, he would get to recoup his attorney's fees and the tenants would not. The tenants would be responsible whether they won or lost for his attorney's fees. That he could break the lease if he found someone who was willing to pay a little bit more money. And there were all kinds of little niceties in there like these that made it just probably the worst lease I've ever reviewed. The problem is, if the tenant has said in the agreement itself that they had an attorney review it, that they looked at it and they read it and they understand the contents, that they can be held liable for the contents of the lease. So this is something that ended up costing them a lot more money than it should have cost them if they had had someone simply review the lease in the beginning. It's not that big a deal. It shouldn't cost that much money. It shouldn't take that long, but its value is tremendous. And that's case study number 1. Case study number 2 involves 2 individuals who are friends of mine and who are involved in what I would call a business breakup. They got into business together, they were in a romantic relationship, and they had complementary skills, and they decided to get into business and, try to grow the business. First year, struggle. It was tough to get the business going, but they managed to get it going. One person began to resent the other person, whether it was on the personal front or on the business front, but they didn't feel like the driving force didn't feel like there was an equal commitment to the success of the business. This led to a deterioration of the business and a deterioration of the relationship. However, there was no documentation in the beginning that stated who owned what percentage of the business, and when it came time to go their separate ways, they spent more time and money hiring attorneys, fighting over what was the percentage share, what was the exit payments to one partner, and what was the ownership of one partner going forward, than they would have if they had simply signed an operating agreement in the beginning, which laid out all these things. Unfortunately, businesses oftentimes come to the point where, or partners come to the point where they realize that they cannot continue to work together as partners, and for the survival of the business, it's best that they explore the dissolution of the business. It's like a real estate transaction. When you buy, you ought to think about what's going to happen when you sell. With a business, before you get into business, you ought to think about a worst case scenario, and you ought to get an attorney involved to draft a simple operating agreement that contemplates these various things that happen in the life cycle of a business. Case study number 3 is the dreaded non-disclosure, non-circumvention, and/or confidentiality agreement. And I have a real-world case for you that is happening right now. So let's say you're an individual and an employer reaches out to you because you have certain skills, expertise, experience, talent, and most importantly, contacts. You have what's called a portable book of business. So an employer reaches out to you and says, look, I'm interested in bringing you on, and I like the fact that you have experience, but you know what? I want you to sign this non-disclosure agreement. You say, okay, great, because I'm going to be able to make more money on my own book of business, I'll do it. I won't review this non-disclosure confidentiality agreement because, what does it matter to me? These are my clients. Well, that's a real-world mistake. And the way it is a mistake is because the non-disclosure agreement often says that irrespective of the fact that you've brought business to the table, once you sign on with this new employer, those contacts, that information becomes the confidential information of that employer. So let's say a couple of years down the road, or even less time than that, you decide you want to take what you think is your portable book of business with you to your next opportunity. That's where the trouble comes in, because the lawyer for whom you sign or with whom you signed the confidentiality agreement is going to say, those contacts and that information belongs to me, and you cannot take it with you. It's a real-world situation. It's a situation that I'm dealing with right now. It is best in this situation to have an attorney review a non-disclosure agreement, a confidentiality agreement, a non-circumvention agreement, because you want to protect yourself and your future opportunities. My name is Bob Arnold. I'm a business attorney here in Miami, and I help businesses through all phases of the business life cycle, whether it be startup or adding a partner or financing or the unfortunate circumstances in which they have to dissolve. I can help. I'm at the Victoria Law Group. Look us up online. Give us a call. We have a half-hour free consultation. I think it's very important to spend a little bit of money in the beginning versus spending a lot of money in the end to bring in an attorney to fix something that could have been handled in the beginning. Thank you.